Let's jump right into this explainer. Today, we're taking on an everyday cosmic perspective to explore a massive, sprawling solar system of red tape, specifically the one created by Colorado's brand new gun legislation, Senate Bill 25003. We're going to break down exactly how this entire system actually operates, looking step by step at the documents and the major legal challenges directly tied to it. Right off the bat, this brings up a massive constitutional question that federal courts are grappling with as we speak. At what point does a mandatory safety requirement effectively become a ban? I mean, when does a bureaucratic hoop that you have to jump through turn into an absolute insurmountable wall? We're setting an impartial stage here to map out the constitutional clash ahead, looking at the state's goals on one side and the fierce pushback from gun rights advocates on the other. To ground this whole thing, it really started with a single stroke of a pen. Down at the Colorado State Capitol, Governor Jared Polis signed SB25-003 into law, and that kicked off a massive bureaucratic orbit that's set to take full effect on August 1st, 2026. Now, the law has a lot of moving parts, but its biggest game changer by far revolves around a totally new regulatory framework for buying certain types of firearms. Okay, let's dive into this because it doesn't apply to every single gun out there. It specifically targets what the law defines as a specified semi-automatic firearm. We're talking about semi-automatic rifles and shotguns that take a detachable magazine, as well as gas-operated semi-automatic handguns with detachable magazines. Now, it does carve out exemptions for things like recoil-operated pistols and bolt-action rifles, but make no mistake, it captures some of the absolute most commonly owned semi-automatic firearms on the market today. So here's the baseline reality taking shape for those specific firearms. Starting on that August 1, 2026 date, the manufacture, distribution, transfer, and sale of these specified firearms are outright prohibited in the state of Colorado. Literally a ban on new sales. But there is an exception to this prohibition. You can still purchase one if, and honestly only if, you successfully navigate a brand new, multi-layered permit to purchase system before you ever even try to acquire the firearm. So, what does navigating that actually look like? Let's walk step by step through this permit-to-purchase maze. The ultimate goal here is getting what's called a firearms safety course eligibility card. First up, you have to pass a background check conducted by a third-party vendor. Then you take those results and apply directly to your local county sheriff. Third, you got to pay multiple new fees. We're talking a card fee, a processing fee, a record fee, the whole shebang. And finally, if the sheriff actually approves you, well, then you're allowed to enroll in mandatory training. Now, to understand who really controls the entry point to this whole process, we just need to look at this official resolution from Park County. It impartially highlights the local sheriff's statutory authority. The law grants the sheriff of each county, and nobody else, the exclusive authority to receive, review, and act upon these applications. Plus, as the document states, the sheriff has the sole statutory discretion to set the processing fees, and they can completely deny an application if they believe the applicant presents a danger. They really control the orbit here. But getting that initial nod from the sheriff and paying the fees, that's literally just the beginning. The sheer weight of these new requirements comes into focus with one striking figure, 4 to 12. That's the number of hours of mandatory in-person training you have to complete just to get past this stage of the bureaucratic planet. Depending on your exact course path, you are spending up to 12 hours of your time, and it has to be in person, no online shortcuts, just to fulfill the safety training prerequisite. Now, what's really interesting about this slide is the final hurdle waiting for you inside that classroom, 90%. Yep, after sitting through that lengthy 4 to 12-hour training course, citizens have to pass an instructor-administered written exam with a massive 90% minimum grade. To put that into perspective, advocates point out that this actually imposes a higher testing standard on the civilian population than Colorado requires for its own law enforcement officer candidates. Oh, and you also have to physically demonstrate a mastery of gun safety. Obviously, a labyrinth of this magnitude generated immediate legal action. You're looking at the complaint for a federal lawsuit filed against Governor Polis, titled Del Toro v. Polis. The plaintiffs here are disabled veterans, firearms instructors, and the Colorado State Shooting Association. And they are fiercely pushing back, challenging this entire maze as a de facto ban on commonly owned firearms. They're arguing that the process is simply way too burdensome to survive constitutional scrutiny.
If we look directly at the exact phrasing from their complaint, the plaintiffs argue this system creates unconstitutional bureaucratic delays and onerous costs. Impartially speaking, these advocates view the multiple bureaucratic layers, the third-party background checks, the unlimited time sheriffs have to review applications, the 12-hour classes, the undefined fees. They see all of it as a calculated strategy specifically designed to stall or completely stop citizens from exercising their Second Amendment rights.
Let's move to the next piece and see how this builds, because the maze actually doesn't end with the sheriff or the classroom instructor. The law tasks a pretty unexpected agency with managing all these records: Colorado Parks and Wildlife, or CPW. They're newly responsible for developing and running a statewide firearms training and safety course record system. Sheriffs, instructors, and firearms dealers are all going to have to use the system to verify that a buyer jumped through every required hoop.
And this leads to another major point of contention highlighted by gun rights advocates. As outlined here, their primary concern is the creation of a state registry. Advocates are terrified that because CPW has to maintain this centralized computer system to verify everyone's eligibility cards and course completions, it essentially functions as a state-level registry that tracks prospective gun owners. The fear is that citizens are being forced to register their intent to buy specific semi-automatic firearms with the government long before a purchase is ever even made.
And this brilliantly illustrates the ultimate macro-level constitutional clash we're seeing play out in federal courts right now. We basically have two totally different legal philosophies colliding head-on. On one side, we have the state of Colorado's justification, which relies on balancing public interests and safety. And on the flip side, we have the United States Supreme Court's Bruin standard, which relies entirely on historical text and tradition to judge the constitutionality of gun laws. Let's look at the state side of things first. Colorado defends the law neutrally by stating its overarching purpose is ensuring an educated gun owner community. The state argues that these steps are just necessary, common-sense public safety measures. From their perspective, the background checks, the fees, and that steep 90% exam score, it guarantees that purchasers of these specific firearms are highly educated and thoroughly trained to handle them safely. So the crucial point is how that state's justification actually fares under current constitutional law. Back in 2022, the Supreme Court established the Bruin standard. As you can see defined here, Bruin strictly rejects modern interest balancing, which basically means a state can no longer just argue that a law is good for public safety to justify restricting a constitutional right. Instead, if a law implicates the Second Amendment, the government now bears the burden to prove that the regulation lines up with the nation's historical traditions of firearm regulation from the founding era. Which leaves us with this final, pivotal question to ponder. Will a modern bureaucratic maze actually survive the historical traditions of 1791? The Del Toro plaintiffs say no way, arguing there is absolutely zero historical analog for this kind of multi-layered, costly permitting scheme. The state says they absolutely have the long-standing authority to regulate commercial transactions and ensure public safety. It's a fascinating legal collision, and ultimately it's going to be entirely up to the federal courts to weigh the sprawling solar system of red tape against the constitutional baseline of our nation's founding. Thanks so much for joining me for this explainer, and we'll see you next time as we continue to decode the world around us.